The last in a series of law, politics, and media lectures from the Institute of the Study of Judiciary, Politics, and the Media. And most of the semester we've been thinking globally, thinking nationally. Today we telescope in on our own state, and we talk about the New York courts and the way that the media cover those courts, the politics of those courts. And we have somebody here who spends all his time thinking about that. He, like me, is a fake lawyer, somebody who has worked as a journalist his whole career and covering, I guess, most of that time, covering law and lawyers in the courts, but without the benefit of a law degree. So you'll get to challenge him, you law students will get to challenge him on whether you think he has the goods. But I had the privilege of working with Dirk Olin at the American Lawyer for, I guess, 4 years. We overlapped there, and learned that he is a journalist with a lot of talent as both a reporter and an editor and somebody who can conceive of new ways of writing about the law and lawyers. Dirk Olin is the executive director of the Institute for Judicial Studies, a nonpartisan, non-ideological think tank devoted to collecting and disseminating data on the performance of judges. I watch his Lex Press blog every day, and watch the reports that he and his staff produce daily about what's going on around the state in the courts. And it is really not what you are going to see in the New York Times, the New York Daily News, the upstate newspapers. It is original reporting that I think is sorely needed. And so he's going to tell us about that operation, tell us the purpose of it, and about the other sorts of activities that the Institute is engaged in trying to provide a new level of accountability for New York's courts. Dirk is the former national editor of the American Lawyer and a longtime legal and political journalist for such publications as The New Republic, Mother Jones, the New York Times Magazine. He edited California Lawyer Magazine and SF Weekly, a San Francisco alternative newspaper. I guess that was after California Lawyer, but mixing up my chronology. But that would be in the general interest category. Most of these other positions have been in covering law and lawyers. Dirk is a graduate of Dartmouth and the Medill School of Journalism at Northwestern University. Please welcome Dirk Olin.
Well, good afternoon. As you can tell from Mark's recitation of my resume, the chief defining characteristic is that apparently I can't hold a job, which is why I went out and essentially sort of created my own this time, and which is what I'm involved in on a day-to-day basis. I did spend 4 or 5 years with Mark overlapping at the American Lawyer, where that magazine, despite the nomenclature, is really about the business of law. It's really, its purpose is to make the world safe for multinational lawyers. And it made a fetish of measuring the business of law, the salaries of law, as you well know, and finding different ways to slice and dice that data for people who claimed to despise and disown that publication, even as they read it every hook, line, and sinker. The reason for that was that lawyers like to think of what they do as a profession, not a business. And as we had a conversation at lunch today, which ultimately concluded, at least my conclusion has been for some time, that it's both. And what's important, the reason I bring all this up, is that lawyers, and particularly the half of lawyers who are in the courtroom, as opposed to merging Fortune 1000 companies or bundling up real estate investment trusts, the half of all lawyers who are in the courtroom are, in many respects, the primary consumers of the law and of the judiciary. But they are not, in my estimation anyway, the most important audience, or to be crass about it, market for consumption of the law and the judiciary. And that's because the judiciary does, in fact, constitute the third branch of government, and in many respects, as we're learning in Iraq and in other places around the globe, in some ways the most important in that it is defined in a very different way from executive and legislative branches. So with the resume and with the background and all that, let me just say that the real reason I'm here, however, is because I'm a Chicago Cubs fan, which I will explain in a little while, and which is undoubtedly driving Obi crazy because he wouldn't know which end of the bat to hold, I can tell you. But let me just ask a question first. Show of hands, how many of you have voted in a recent election? How many of you voted for a judge in that election? How many of you can name any of the candidates for the judiciary that you voted for? Right. So, so knowing that, let me ask you, and you're predominantly law students, is that right? Somebody want to take a crack at this? What's a judge? You're going to be lawyers. What's a judge? Anybody?
It's a lawyer who knows the governor.
Yes, under appointive systems, that's true. Of course, we have an elective system, so you don't really need to know the governor. So I reject that definition.
Okay. The person who presides over a trial or a court?
Very often the case, although there is a phenomenon that that we're very aware of, which is the disappearing trial. In fact, most litigation never goes to trial. So you're right, though. I mean, a judge is someone who presides over that apparatus. Ultimately, a judge is, with apologies to the president, a decider. And he is someone who is deciding how to apply the law to a set of facts. Those facts are arrived at either by the judge herself or by a jury. But the way that the judge comes to that conclusion is very important for the public at large to understand, and I fear that we don't. And that's at our peril, because we don't realize the important sociological role that a judge fulfills as distinct from those other two branches of government which are elected. So the key thing about that judge is that unlike an executive or a legislator, the judge is not majoritarian. The judge does not have to build some temporary constituency to get into office the way Hillary trumped Obama yesterday in Pennsylvania. The judge is theoretically not supposed to do that, except when you have judicial elections, in which case we're on the horns of a dilemma, because the judge has to do that to get into office and then pretend that she didn't say anything to get there. I was reminded of this 2 weeks ago on a panel with a couple of one sitting Supreme Court Justice and Sandra Day O'Connor was there, but it was Breyer who brought up his own visit to the Soviet Union, the former Soviet Union, in about 97, right when Yeltsin had taken office. And Breyer was remarking upon the great prevalence of the phrase that was used all over Russia, which is telephone justice. I kept hearing this, and after a while I said, what the heck is that? Well, that's where somebody in the Politburo calls the judge and tells them on how to rule. There is no way in that system that you're going to have anything other than a gamed and tricked up apparatus that serves whoever can, as Mr. Bybee pointed out, get to the governor or the executive office holder in question. Okay, so we've got this rough idea of what a judge is. What's a judicial election? Well, as I said, I think it's oxymoronic. What I really think it is a sham. Because, as I said, we ask judges to go out and be very circumspect about how they are going to rule on fact-specific cases. And yet, one jurisdiction wants a hang-em-high judge. One jurisdiction wants somebody who's going to be lenient and treat society as the criminal. And at the end of the day, we don't have a rational way to put that person in office and have them arrive at these facts in a dispassionate way. Now, In New York, as you may or may not know, for the past few years, there was a lawsuit brought by a judge by the name of Margarita Lopez Torres, who sued the party bosses, among others, for denying her their endorsement. And she said that they denied her the endorsement. If I remember right, she was a civil court judge who wanted to be a surrogate judge. Take that back. She became a surrogate judge subsequently, but she wanted to sit on the Supreme Court, which is elected. She claims that the party bosses, and one in particular, wanted her to put someone on the payroll. And when she didn't, they denied her the endorsement. What the U.S. Supreme Court said earlier this year was, that might be true. Maybe that's true. Too bad. Tough luck. Political parties are private associations. They get to come up with whatever rules they want. So, apropos of last night, if Hillary continues to beat Barack Obama and we end up with a frozen primary process and a brokered convention or something prior to that, and many of you may or may not have read that former Solicitor General Ted Olson has offered his services to the Democratic Party to relitigate Bush v. Gore, and I think they will decline. But in fact, I don't think that that's going to be the governing case if this ever goes. I think that Lopez v. Torres versus the New York State Board of Election will. Because at the end of the day, whatever Howard Dean and Donna Brazil and 6 other people decide in a back room about how they're going to pick their nominee is going to stand. 9-0, the U.S. Supreme Court said, to quote Thurgood Marshall, you cannot stop a legislature, or in this case a party, from enacting stupid laws. The end. Okay. What does that mean for us as a practical matter in New York being one of the, between 35 and 40 states, depending on how you want to count it, that elect our judges? Well, we have what an acquaintance of mine who's a professor of law at Indiana named Charlie Jay calls the Rule of 80. And the Rule of 80 states the following. 80% of the electorate says they want judicial elections. 80% cannot name anybody on the ballot. 80% don't vote. And 80% think that contributions to judges corrode the integrity of the judicial process. Now, ask yourself, who's going to donate to a judge? In most jurisdictions, most of the time, and particularly given what we saw here, that none of us, and I promise you, despite being a legal journalist for many years, I have voted in plenty of judicial elections where I didn't have God's own clue who I just cast my ballot for. Given that reality, the system gets hijacked by who? By the litigators who appear before the judge. They're the only ones with a vested interest. There's the currency. That's the buy and sell there. And I would hasten to add that, lest you think that this is somehow the way of all flesh, it is, alas, an example, a negative example, in my view, obviously, of American exceptionalism. We're the only industrialized country in the world that does this. And by the way, we didn't do it originally. Almost every state from the late 18th century into the Jacksonian era had appointive systems. But during the Jacksonian era, because the appointive system can get corrupted like anything else and became a spoils system, everybody thought, let's have elections. That'll be clean, that'll be transparent, that'll be honest. Of course, that was in a day when the way a lot of voting took place was you'd get a bunch of people liquored up, take them down to the ballot, watch them cast their ballot, or they'd say it out loud before they put their vote into the box. So I'm not sure how much transparency we were gaining. And in fact, that's where you get the phrase ward healer. If you've ever heard that, because he's walking behind people on their heels down to the ballot box. Now, okay, this wouldn't be the worst thing in the world if somehow we had elections that looked at the candidates, asked in a sober way what their knowledge of law was, what they had demonstrated by way of temperament, commitment to the community, pick your own good government criteria that you would want to use, But it doesn't work out that way, and it's getting worse. And one of the reasons it's getting worse is another Supreme Court ruling recently, which was the Republican Party of Minnesota v. White. And not to put too fine a point on it, what that case basically said was, you can't tell judicial candidates what they can and cannot say in an election. Well, welcome to devolution. There are plenty of jurisdictions. Wisconsin, if you want to go look up a recent one, just had a horrible election that resulted in the incumbent being thrown out for all the wrong reasons. And when I say the wrong reasons, by the way, I re-stress the non-ideological nature of what our think tank does and what Judicial Reports does. Critical studies, originalists, activists of whatever stripe, I don't really care. That's not my point. I'm not here to vet the philosophical or jurisprudential leanings of the individual judges. I'm more interested on process, which, again, relates to why I'm a Cubs fan. We'll come back to that. So, what you have to ask yourself then about this process of electing our judges, which in New York, of course, is oxymoronic because what it really is a de facto appointive system that looks like an elective system, right? You've got party bosses, classic smoke-filled rooms, tapping people on the shoulder. It's like you're joining a frat or something. And then people have to go to these little mini conventions. The judges have to leave the room while they collect money. The judge comes back in and pretends that all the people in the room didn't just give her money. Then they hold the election. And in the 5 boroughs of New York, the nomination is tantamount to election because of the Democratic Party dominance. In other jurisdictions, upstate, and I should say, qualify that on the 5 boroughs. Staten Island has been fairly competitive because it used to be all Republican, and demographics has sort of shifted there. So you see some competitive races there. You see the same thing starting to happen in Westchester. But if you've got party dominance in one particular jurisdiction, the nomination is tantamount to the election. The party bosses run the nomination. Ipso facto, you have an appointive system, but an opaque appointive system and in my opinion, corrosive appointive system. So, what this, you would think, might lead... Yes?
Upstate?
I'm sorry?
You didn't finish on upstate?
I haven't spent a lot of time I should say that we have spent our early days focusing downstate on New York City. And I haven't gone, I don't know upstate politics well enough to know, what's happening in Buffalo versus Syracuse versus Albany. I mean, I know Albany as an island, has its own island of Democratic Party dominance. But you may know better than I whether, anyway, I don't. We haven't spent a lot of time up here yet, although we plan to. But at the end of the day, what's interesting is we did some studies. So we immediately thought, oh, you know what? Since we think that these guys got elected through this sham process, but since we know that there's a cadre of others who were appointed when there are vacancies, they don't hold the election, they're appointed, or you can also elevate them from the lower courts, which is a whole nother kettle of fish, where you have half the Supreme Court judges, which is the Court of General Jurisdiction in New York. So that's the law and order judges, basically. Half of them actually are elevated from the lower courts by the governor or the mayor. And so we thought, well, this will be great. We'll be able to show that elected judges, by a variety of metrics, are inferior to appointed judges. And when I say by a variety of metrics, it's because one of the things that we do, Judicial Reports looks at judges the way Consumer Reports looks at appliances. And we've measured their performance according to a bunch of different metrics. Now, I'm a journalist by training, as are the people I work with. So we don't think that you can judge a judge by statistics alone. But we also don't ignore them. We surround that statistical analysis with shoe leather reporting. Long and the short of it is, one of the things that we have calculated for all the 300-plus Supreme Court judges in the 5 boroughs, and now adding Nassau, Westchester, and Suffolk, is their reversal rates. So we look at all the times they've been appealed, sorted according to what kind of judge they are, so that you're not comparing a matrimonial judge to a criminal term judge handling arraignments, and actually ascribe quartiles to them in a way that would be dangerously reductionist, except that we also provide all our clients with a full bibliography of all the reversals so they can go drill into that and find out what happened in that particular case. Long and short of it is, there was no statistical difference between elected and appointed judges. So I am not here to say that an elective system automatically gives you bad judges. It probably doesn't. What it gives you is a bad polity, is a bad commonweal, gives you bad politics. Bad cases make bad law. Well, bad electoral systems make bad electoral systems. I don't know how to put it any way other than that. And that has bad effects down the line. So what's a bad judge? What's a bad judge? Well, Gerald Garson was a bad judge. Gerald Garson took a bunch of money from lawyers before him to either redirect their cases to friendly judges or actually to vote in the way that they wanted him to vote. His brother was actually an acting Supreme. Gerald Garson was a civil court judge. His brother was an acting Supreme Court judge. Just pled out yesterday to basically robbing from mommy's estate. So the Garsons' parents have some answering to do. I guess mom doesn't since she's no longer with us. But no question that bribery makes you a bad judge. Stipulated, okay. But Laura Blackburn 2 years ago got bounced from the bench because when she was sitting at court, found out there was a sheriff out in the anteroom outside her chambers, waiting to take the defendant who was before her into custody. Blackburn was livid and said, I'm not going to become a holding tank. I'm not doing the sheriff's business. He wants to go out and track down defendants for other reasons. Let him do it on his own nickel. She let the guy out the back door. The Commission on Judicial Conduct didn't so much like that, and they bounced her off the bench. Okay, so that seems fairly clear-cut, but now answer me this. Here's Marilyn Diamond. In the spring of 2006, the Commission on Judicial Conduct, which, by the way, is it's the Internal Affairs Division. It's just what it sounds like. They investigate complaints against judges. Although we'll talk about some of the ways they do and don't do that in a minute. In the spring of 2006, the Commission on Judicial Conduct began investigating charges that Diamond asked a court reporter to alter official transcripts to conceal her relationship with litigants who had appeared before her. Separately, Diamond and two associates were involved in a lawsuit over an art heiress's estate. The deceased's family alleged that Diamond and her associates, who were co-trustees in the estates, had taken millions of dollars. In 2005, a federal judge froze the assets and ordered Diamond and her associates to begin settlement negotiations. I'm not done. In 2004, the Appellate Division upheld Diamond's handling of a foreclosure, though the dissenting opinion noted that she should have recused herself for owning stock in the mortgage holder's parent company. You would think. The following year, the FBI investigated Diamond in a child custody ruling in which she ruled for a divorced heiress, despite serious allegations of abuse, who was a client at the same nail salon. Well, okay. But
crossing into dangerous territory.
exactly, no, exactly so. This is what right. But that's what But see, this is the point of what the Commission on Judicial Conduct does and doesn't have to do. But more to the point, it's not just that they knew each other in that, but who had once served as a real estate broker for the building that the judge owns. So she had a business relationship with this person. It's not just friends sitting in the next chair of a barbershop or a salon. In 2000, Diamond complained that she had received a series of hostile letters that contained anti-Semitic remarks and threats. She was given 24-hour protection until the police concluded that she had fabricated the letters and the investigation was closed and the 24-hour protection was rescinded. Marilyn Diamond's still on the bench. I have a problem with that. A closer case on a name I'm not going to mention is one that we're investigating now. And this is where the distinction between what the folks who litigate down in the trenches will tell you is the distinction between a corrupt judge, Gerald Garson taking bags of cash at a diner, and a bent judge. So the judge that we're looking into right now, and of which there's fairly considerable evidence, is alleged to be lengthening proceedings before him or her on whatever court he or she sits on, so that a series of guardians and receiverships can be doled out to friends of said sitting judge. This is really hard to prove. judge grants a continuance that's requested by one of the parties. Suddenly the expert witness who was testifying today has to come in tomorrow, gets another per diem. How do you prove they have a relationship? Maybe you can, maybe you can't. So I give you those four descriptions because they go to the varieties of judicial misbehavior. I hasten to add, they are the vast minority. Most judges are really smart and really good at what they do. But I've never subscribed to the bad apple theory. Oh, this one bad apple proves that the rest... No. If there's a bad apple, there's typically a worm crawling through a bunch of different pieces of fruit. And we're about trying to track down the worm. So this brings me to the Commission on Judicial Conduct, which recently saw its budget double. I'm imagining, I could be wrong, but I would think that if you all were up here during the last year, you would have read the big series in the New York Times on town and village justices.
It's required reading for today.
Okay. I don't know quite what to do with this, but I was very happy with that series. I thought it did a public service. I guess I wish it had come second, third, fourth, or eighth. The town and the village justices of New York are very important to their small communities, but they are not making the bulk of the law. And that's an expression. Judges don't really make the law. But they are not making the bulk of the law that affects the most people most of the time throughout the course of the year. That's happening in much bigger jurisdictions with much bigger and more important courts. And yet, the Commission on Judicial Conduct leveraged that series by the Times to double its budget, which is now up to about $5 million. Now, the CJC does a much better job than most other states, and the statistics will show you this. But 50% of the complaints that come before them are for these town and village justices. And a town and village justice is more than 3 times more likely to be investigated by the Commission than a civil or criminal or Supreme Court judge. Now, anybody else would call that selective prosecution. Maybe those town and village judges really are worse. Maybe those complaints really are more viable. And certainly a lot of those town and village judges are not lawyers. Some people might think that's a good thing. I don't. I'm not a lawyer basher. It does, however, raise the question about how you promote greater transparency and good judging and an understanding of good judging by the public at large. So if we've asked ourselves what a bad judge is, let's ask ourselves what a good judge is. Well, in South Dakota, they spent 2 years telling you they thought exactly how they could ensure that you'd get a good judge when a bunch of, pardon the expression, yahoos spent 2 years running a campaign called Jail for Judges, in which they were promoting a state statute that would have convened a civil grand jury to review the rulings of judges based on a rap sheet of criteria that could be completely decided by the grand jury. And if a judge was overruled by this grand jury 3 times, they could do time. This betrays a profound misunderstanding of the place that a judge is supposed to hold in our society. This is why they confer judicial immunity on a judge. You can't sue a judge because you don't like his or her decision. Nor should you be able to. This from a guy who is, as you just heard, very interested in ferreting out corruption or bad judging. But as we like to say at Judicial Reports, we are against irresponsible judge bashing. We're just in favor of responsible judge bashing. So Jail for Judges, thank goodness, was voted down. However, you all saw in the Terry Schiavo case, or Wisconsin Representative James Sensenbrenner trying to restrict federal judges' junketeering, even though Sensenbrenner himself was number 2 in the U.S. House in junketeering over the last 5 years. Again, displaying this deep suspicion of judges. And I think that this deep suspicion of judges is wrong-headed but completely understandable. And the judiciary itself has contributed to this problem precisely because, for two reasons. One, there's a cliche out there, it's called black robe disease, and if any of you end up clerking, you'll see it manifested in some judge down the hall, not the one you're working for, of course, of tremendous, I mean, some judges, they're judges are people too. Just like bad editors we've worked for, you can have a judge who's incredibly arrogant, incredibly full of himself, borderline irrational, frankly not displaying judicial temperament. Happens all the time. But even that's not the problem. The problem is that the judiciary itself pulls back behind this screen of judicial independence and says, can't touch this. And in my opinion, what that leads to is a reactionary response. So what we have to ask ourselves is how we go about creating greater transparency and accountability without threatening judicial independence. Unfortunately, there's been a false dichotomy out there for years that those two things are in mutual opposition to each other, when in fact they're flip sides of the same coin. If you don't have an accountable judiciary, people are going to start coming after it for all the wrong reasons. Toward which end, something that we are pursuing now, it's going to sound horribly nerdy, and it is, but it's also vitally necessary in my opinion, which is called judicial performance evaluations. You'd think this wouldn't be terribly controversial, right? You go into any Fortune 1000 company, and employees are reviewed. There are legions of industries that are built on figuring out ways to measure performance by different professions. Well, and come to find out, there's actually been a legion of scholarship on how to measure the performance of judges. And we know how to do this pretty well now. These are academically peer-reviewed, gold standard systems that ask anywhere between 30 and 50 questions, basketed according to knowledge of black-letter law, negotiating ability, temperament, efficiency, so that no one of these things, there are debates all the time between, say, the Rocket Docket, which is down in the Eastern District of Virginia, I'm talking about the federal bench now, versus the Southern District of New York, which is famously slower. You can't compare this. It's apples and oranges in terms of the kinds of cases that come before them. But measuring individual judges based on all these criteria can give you a very balanced view of what they do. So now we come down to me being a Cubs fan. So if any of you follow baseball or even have a vague, it's the 100th year now. It's 2008. The last time the Cubs won the World Series was 1908. This is pathetic. How does that lead me to being a judge nerd? Well, at the end of the day, if you're a Cubs fan, you haven't been able to care for a long time about who won the game. All you could care about was how it was played that day on the field. So Cubs fans become very good at rationalizing loss. We lost, but, they got the bunt down in the 7th inning and we tied it up. And, yeah, I'll grant you that we gave up 9 runs in the 8th, but still, we were playing some pretty good ball there for a while. In other words, it's process-oriented, not results-oriented. And that's the way that judges need to be viewed. So, in fact, one of the inspirations for what we've been doing at Judicial Reports is this guy in Boston named Bill James. Bill James started looking at baseball players 15, 20 years ago, according to, pardon the expression, a bunch of different metrics. So he doesn't just look at how a batter hits. He asks how he hits on a windy night, how he hits during day versus night, lefties versus righties, when they're behind, late innings, early innings. Looks through all of this different stuff through 100 different telescopes, and looking through both ends of the telescope, I might add. So that's what we've been starting to try to build out with Judicial Reports. Now, at the end of the day, the problem here is one of patience. Court TV, which Mark and my former employer once owned, started, maybe you'll recall, can't do the math and figure out how old you would have been during O.J.'s trial, But Court TV was up and running in the 90s, and the problem was there's only one OJ trial. And guess what? Even the OJ trial wasn't very bloody interesting, except for the miscues. Trials don't make good TV. Judicial performance evaluation doesn't make sexy government the way that elections do. But at the end of the day, as I pointed out before, whether you're talking about the Soviet Union or Iraq or our own fragile democracy, I would argue that figuring out how to square this problem is one of the signature ones before us. And we need to extricate ourselves from the histrionics at both the federal level and the local level, which is why we've started out with where we've started out, which is at the grassroots level with the New York State court system. So now that I've bored you with why I'm a Cubs fan and why we do what we do at Judicial Reports, I am open to any questions you have.
What's the difference between judicial performance evaluations done by journalists and those that are done by the bar or bar-type organizations that would seem to be more a safer model for the judiciary to cooperate with?
Right. So Colorado, for reasons that escape me, Alaska and Colorado are, and I don't mean this flippantly, I just really don't know why, but Colorado and Alaska are real progressive. They're way ahead of lots of other states in how they do this sort of stuff. And Colorado, despite being really progressive and they have what's called a judicial retention election system, where you are appointed, but then you stand after a number of years for on an up or down vote by the electorate. Should Judge Obey be kept in office? And they have a judicial performance committee that's part of the state apparatus that uses a sort of a bot that crawls over judicial decisions over the circumscribed period, I think 18 months, it might be 2 years. They pull up all the litigators on both sides of anyone who's been before Judge Obey during that period. They aggressively reach out to them to get a decent response rate. And if Judge Obey comes below some certain threshold, this judicial commission lets the judge in question know that he or she is not going to receive the good housekeeping seal for retention. And so far for the past 5 years, what that's meant is that those judges just don't stand for re-election. They quietly skulk away. That, to me, is exactly what's wrong with a state or bar association engaging in that kind of process. Because even though it's very results-oriented. Yeah, it arguably gets bad judges off the bench, but it hasn't told anybody out there, what a judge does and how she does it. So, that's number one. Number two, bar associations don't have the time or the resources to have gone through this academic process in anywhere near an assiduous enough fashion. And I'm sorry if I'm offending any future aspirant bar association presidents here, although I would refer you to Mr. Obey's piece in Slate of a couple years ago on Harriet Myers. People who run for bar association presidencies, people who run for that stuff are, and I ran for student government once. I mean, shoot me now. But the point is that bar association leaders are not profiles in courage most of the time. And, by the way, not for nothing, judges sit on a lot of these bar associations. So you just get all kinds of conflict in there. So that's number two. Number three, none of these people is adequately trained or resourced to do the big piece, the third leg of the stool, in my view, which is to surround that performance evaluation system with journalism. To get back to my point about not just stratifying judges according to statistical report cards, which is good, but to actually, put them in the context of Jack Weinstein down in the Eastern District is probably the most reverse judge on the Eastern District. So a lot of people think he's one of the best judges in the history of mankind. And I mean people to the right and left. So the report cards, statistics, it's good stuff. It's good stuff to add to the database. But at the end of the day, if you don't surround it with explanatory writing and narrative, and analysis, I don't think that you get where you need to be.
We actually had Justice Venky Kormos come out and speak.
Oh, yeah.
As a real booster of GPs.
Absolutely.
From Colorado model. And what was interesting is she actually blamed whatever failures there were in Colorado with their system on journalists. And
For
said
hijacking it and making it sensational?
No,
Oh.
not ignoring it.
Oh, for ignoring it.
Yeah, and she said so that she had identified some of the same weaknesses, that they do these. She actually thought that the gathering of information was really good. But
I think it probably is, yeah.
But there was no, the journalists just didn't consider it to be news.
But they don't make this stuff public. See, what Becky won't tell you is that they hold a lot of this stuff close to the vest. So what they want, and it's understandable. There's this balance between maintaining confidentiality. You get rogue people, again, results-oriented people who are going to go out, or the judge was mean to them that day, or they're a crackpot, or there's all kinds of reasons why you need to protect the judge from scurrilous allegations. But if they don't figure out a way to balance and make more transparent that stuff they're keeping inside, I don't know, if I were a journalist and somebody came to me and said, would you like to see the results of our surveys? Like, yeah, sure. Well, we can't show them to you, but we can tell you this. What? What are you saying? Here are the 6 people who received our endorsement for the retention election. Well, what about the others? Well, they might have not gotten our endorsement, or they might not have shown up for the interview. Well, which is it? Can't tell you. How do I know whether they're... So that's why I think at the end of the day it's important for these things to be extricated from bars, extricated from state apparatuses, and run more on a... He's controversial now for other reasons, but more on a Ralph Nader model. Somebody independent of either or all camps who can really report on appliances or cars or safety, or in this case a highly nuanced governmental service, as the phrase goes, without fear or favor. That's us or somebody like us.
Yeah, it seems to me there tends to be a lack of peer review on the whole in professions. And I have seen this, for example, in land surveying, which I was involved with, not as an official land surveyor, but as thinking of becoming one. Canada has a robust peer review system where they can go into a surveyor's office and grab cases, the review board, grab cases, take them out of the office, have them reviewed by peers for their sufficiency, you might say, and have that have an impact on the already certified surveyor's standing in some way. I'm not sure exactly.
You mean they're analyzing the jurisprudence for its competence?
No, this is land surveyors.
Oh, land. I gotcha.
Okay, so they do it in Canada. They have a Robe. I think, from what I've heard, I haven't seen it operate. They have an in-place, robust, professional category review of certification to
Right.
see if the guy's doing his job
Right.
for the clients.
Right.
But I think what I'm saying is you don't see that in the medical profession.
Right.
You don't see it in the legal profession.
Well, you do see it partly in the legal profession in the following way. That's why we have appellate courts.
Well, but I'm saying within the peers, though. You don't have one law firm saying, okay, we're going to have a firm from Nebraska come into our Syracuse firm. They're going to go through the partners' files, and they're going to pull 2 cases from each partner, and they're going to review them
Right.
for a period of so many hours and come up with an evaluation if the partners are really doing a good job.
Right. No, I think that's right.
But I mean, that would be entirely possible and could be...
Define possible.
Well, it can be relatively confidential. It's not like that goes in the newspapers.
Right. Well, then, if you're talking about private actors there, private firms, you might be able to pull something off, although I'm here to tell you the culture of at least the, most law firms would never truck with that. Here, though, we're talking about public actors. And the problem is that this tension between confidentiality and dissemination of the results it's just as important to figure out how you convey this information to the public, in my mind, as it is to actually conducting it. I mean, there is a self-improvement component to judicial performance evaluation. In fact, it's in most ways that it's practiced around the country, that's its chief function. They do some sort of confidential evaluations. It's brought to the judge, him or herself, how they fared on these polls, and to the administrative judge in question. But it's not shared beyond that, and so most people think it's like the internal affairs police department where they're brushing stuff under the rug, whether true or not.
You mentioned that if one of these evaluation committees came to you and said, "We have a survey, will you take a look at it?" You'd say, "Oh yeah, definitely, I'd take a look at it." Do you think that holds the same for sort of traditional media sources, or where the general public gets their information from? Is that, and I mean, I don't know how much interaction you have with those sources, but is that something that, where the general public would get the news that would apply
right.
there also?
Well, it's interesting. I mean, go back to my baseball analogy. We don't have law sections of mainstream papers. But we, and I include myself in this because I just did it for about 15 minutes before I came in here, will spend an inordinate amount of time with a box score of a baseball game. The public at large is not going to do that with this stuff. So, and nor, alas, are most journalists, even in the mainstream press, interested in doing anything other than stenography from the previous day's rulings. With the exceptions of that. You've had Dahlia up here?
Not in this
Not this-
series, but yeah, she's been on campus a couple
So
of
Dahlia Lithwick, who writes for Slate, and Tony Morrow, who's a former colleague of Mark's and mine, in my opinion, I don't know if you share this, but they're rarities. This is probably going to change, by the way, with the advent of new media and the blogosphere and more individualized and opinionated media. But for years, they were the only two reporting on the high court with anything like, I guess what I would say, institutional disinterest. So not until Bush v. Gore do the scales drop from Linda Greenhouse's eyes. And so the point there, I guess, is that it's a bit of a paradox. The only way to do something like what I'm doing is to nicheify it like this, right, and make it for judge nerds and law nerds, but then try to figure out some way for it to achieve escape velocity. I'm going from vertical to horizontal here. And so we've spent a lot of time creating mutual links with the Daily News and the New York Times and the Post and Newsday. But the other nicheified publications, the likes of which we used to work for, and I want to be careful here because they're, because I worked there for a long time, and so I might have participated in a certain amount of conflictedness, either without asking too many questions myself, B, because it's changed, and C, because I can't say this with absolute certainty, but in most of the big jurisdictions around the country, you've got publications that have a monopoly on judicial news, by which I mean the calendars and the legal notices and the rulings of the previous day, and they are the official paper of record for the Court of New York City, New York Law Journal, which was owned by the company we both used to work for. The problem is that monopoly is conferred on them by the Judiciary. So they're printing money hand over fist, depending on the company. And their margins are fabulous, but, they, if you look, and I used to run the San Francisco Daily Journal, okay, which was in competition with the American Lawyer Media paper in San Francisco. San Francisco actually has 2 legal affairs dailies, if you could believe it. And if you ever want to see a real argument for competition, there it is, because they're both, in many respects, better than the daily paper, the San Francisco Chronicle, which has no competition. But, if you looked at the profiles turned out by any and all of these publications, I don't know if you ever played Mad Libs when you were little. It's noun, fill in the noun, adjective, fill in the adjective, and at the end you have this sort of absurdist little thing you put together. I mean, it's basically you could churn out these profiles by software. Every judge is tough but fair. Every judge, is irascible this and yet beloved by the And that's because, I don't know why that's because. That's why I want to be careful about casting aspersions. I don't know whether that's a lack of imagination by people. It may be this transparency problem. Maybe at the end of the day it doesn't pay. We're still trying to figure out a way to make this whole operation that I'm doing self-sustaining, and there's a bunch of different things that we talk about for doing that. But at the end of the day, this kind of information, it's hard to figure out how to monetize it. And if you can't monetize something, how do you maintain it? And if you do monetize it, how do you compromise yourself?
I'd be interested in your thoughts on how politically we can get your thoughts, your idea done as far as judges and judge evaluations, because the current system in Colorado seems to be probably about a max, as I might see it, is what judges might currently agree to. How could they be forced to endure a system that would air their curriculum?
Well, I always believe in asking forgiveness rather than permission. So the first answer to your question is, I don't really care whether the judges are going to accede to this or not. I want them to. I guess I'll rephrase that. I do care in that I want them to, and I want to do it the right way, and I want them to, as the salespeople say, have buy-in, and I want them, to be part of the process and to recognize, as most of them do, by the way. Most of them do. When you talk, Venky Kormos was a judge on the Colorado Supreme Court. Most good judges say, yeah, this is good. This is going to separate the wheat from the chaff. And the good judges will be seen for what they are, and we use it only as a means to get either the miscreants or the sloths out of the system. The problem is, as I said, that you've got it only takes a few resistors for it to become too controversial inside of a status quo and resist that. I think that's starting to change. There is a growing body of academic literature on that most judges, after these things have been in place for a while, are pretty happy with them. And in fact, they're happy in the same way that you or I would be happy if we had been in a sensory deprivation chamber for a while. These guys, they really don't, you know that feeling of teachers know this. I wonder if the students are bored to hell right now, or whether they're actually paying any attention. Well, I'll get evaluations from them. And so you get anonymous evaluations, and they either slam you, or you get a few that are intellectually honest, or somebody lets you know which one theirs was, and they're trying to kiss up to you, and so there's all that stuff here too. When in fact most people, even though they resist it at some sort of psychological first level, I think at a deeper level really want to know. In the same way you want to know in high school. Do the girls like me? Do the litigators, do they think I'm doing this well or not? They really do want to know. You've got to convince them that it's going to be a fair process. So, in answer to your question, somebody like me needs a big ally. So I was in negotiations with the New York State Bar Association for some time to have them let me survey their members. The problem was, for the first year and a half of it, they said, you remember I mentioned Lopez Torres versus the New York State Board of Elections. Because this is to give you an idea of how high school this is. So the New York State Bar Association had not signed the amicus brief for the judges. So the judges were ticked off at the New York State Bar. So the New York State Bar wouldn't let me survey their members. Seems a little weird. However, even if they did, then you have a technological problem. Now we get to why am I doing this? I couldn't have done what I'm doing right now 10 years ago. Probably couldn't have even done it 5 years ago. This stuff was not retrievable in any kind of electronic way, and it's still really hard to get. But in Colorado, for example, they have, as I said, they've got this bot that they can go and immediately generate this list of litigators on either side of a judge for the previous time. I don't know of another state that has it. So we overlay about 9 different things so that we can generate a list of the litigators to go survey. And we use that as a tool when we're doing a profile of a judge just to get sources. Okay? If we were trying to convert that into actual respondents to a poll, which has 40 or 50 questions on it, being given to a guy who bills $400 or $500 an hour, trying to get him to spend some time with that poll is problematic. If you've got a good ally who will tell them why they want to be part of that process, maybe they can get CLE credits for it, or maybe they can, there are different ways that you can try to get them to give you compliance, other than doing the right thing. It just doesn't have a high rate of success in my experience. The short answer is you need an ally. I'm in negotiations with a couple different fairly big institutions to see if I can make that happen.
I was curious, in your abacus piece, I guess, from a week ago, you had talked, I guess you discussed that conference in Fordham.
Oh, yeah.
Justice Breyer and
Yep.
Justice O'Connor. And at some point, I believe, it might have been the Widener professor talked about...
Geez, you remember this better than I do.
Yeah. Something about, I guess, an idea sort of getting out of the issue of the elective process for judges with sort of fixed long terms.
Yes. Yes.
And I was just curious what your thoughts were. I mean, obviously you said you don't really support the election system, but do you think that's... And then I guess he also said something about inverting the New York system, where let's appoint the judges and,
right.
and actually
elect the higher ones.
appeals.
Which in New York they have exactly the opposite. Back in the late 70s, in one of the last examples of people giving up their perceived franchise, and I emphasize that strongly, New Yorkers gave up the right to elect the Court of Appeals, which is the New York Supreme Court. Again, the nomenclature here. Supreme Court's down here. The Court of Appeals is the highest court in New York. The electorate gave that up for an appointive system. This gentleman, the professor from Widener, whose name escapes me right now, was saying that's exactly wrong. You want to elect the top court members because, if you remember going back to our discussion of what's a judge, he said they really are acting like something closer to policymakers than to the disinterested members of the third branch. And so it's okay if the public has more feedback or input into that process. It's arguable. The second proposal that he had was that you create limited tenure, in essence. That you appoint, that if you appoint or elect, that they have a long term, but at the end of that they're done and they're out. It sounded okay to me. It was actually the first time I'd heard it. I'm against term limits generally at any level, because it seems to me that what that does is reward stupidity. Like, oh, you've spent 10 years learning the law and becoming a really good judge. Bye. It's crazy. It's crazy. And by the way, when they did that a few years ago at the U.S. congressional level, the result has been complete and utter dominance of the legislative apparatus by lobbyists. Because the fourth branch becomes, and this is not to say, not to even demonize lobbyists. Lobbyists actually, Hillary Clinton had this line about lobbyists lobbyists represent real people. Well, she's right about that. Lobbyists are sitting on a bunch of genuine information that's viable and is important to the give and take of the process. So I'm against, in the same way in the court system, what ends up happening? Law secretaries. Law secretaries become the institutional memory of the court system. And law secretary in this vernacular is really the chief clerk. They help write the opinions and so forth and so on. And they, so there's the ultimate unaccountability, right? You're going to end up with a handful of Sherpas and no real mountain climbers. And I don't know, that's dangerous to me.
What would you think of, because I guess a lot of the life tenure things come from, obviously, the Constitution, appointed for life.
Right,
and I've always wondered if the fact that people live longer today has to be taken into account, because I don't think people would have lived until like 80 or 90. What do you think of a life tenure but a mandatory retirement age?
That's what we have in New York. So when you reach the age of 70 in New York, every 2 years you have to be what's called certificated, because that way they have as many syllables in the phrase as they could possibly squeeze. So if you're certificated, every 2 years you basically have to go show you're not senile, or non-compass for some other reason, or disabled, or what have you. And from what we can tell, it seems to work pretty well. I mean, right now there's a suit that you probably heard about from a couple weeks ago Chief Judge Judith S.K. has sued the state of New York because they haven't received salary pay raises in 10 years. This is arguably unconstitutional at both the state and federal level under the pay diminishment, what's called the Judicial Pay Diminishment Clause, which says you can't reduce a judge's salary during their tenure. And that, again, goes to this judicial independence question. If, you could have people politicizing the judiciary by just cutting their salary to the sitting judges until they leave, and then you put in the ones you want. So and their argument is that the absence of a cost of living adjustment over 10 years is de facto, if not de jure, diminishment. And I think they've got a good case on that. Okay, so why did I bring that up? To hear that case, because they're making, even though there's a federal argument to be made, they're making a state constitutional argument, it can't be removed to federal court. So who's going to hear this case? A New York State judge. Reminds me of, there was this old some ad in the 70s where the guy comes on and says, "And I wouldn't steer you wrong for a very good reason. I'm the president of the company." Like, what possible motive could I have? Right? So now we've got this state Supreme Court justice who's going to hear this case, Edward Lehner. However, here's where the certification process might be serving us well. This guy's in his last year, he's 76. I don't know, and in fact we're reporting out right now, I don't know how this might affect his pension. But at the end of the day, they've got something close to a disinterested justice, and then they invoke this doctrine of necessity, which says, in essence, well, someone's got to hear this case. I think this never made me very comfortable. I mean, it's sort of like saying, someone's got to cheat. Might as well be this guy. Not to say that he would be not do his darndest to be disinterested, but it never seemed like much. It seemed like an assertion, not a logical answer to me. But in that case, they may have found the way out, and the certification process, I think, is good in that you don't want. I mean, think about the old stereotype of the judge. It's some. Let's leave out the gender discrimination of years past. It's some old white-haired Solon, just where the word smart old person who knows how to adjudicate and issue Solomonic decisions. Hopefully not Solomonic decisions, since that would actually cut the baby in half.
Yes.
You hate when that happens. But now the one problem also now is that because of that pay, this argument is brought forward more and more, that because of that pay problem, you actually have a lot of younger judges now who are stepping out of come out of the DA's office or a firm, and they're actually using the judgeship to make their reputation so they then have currency in the private sector or even the governmental sector after the fact. It's an inversion of the old, you make your bones, and then sometime in your 50s, the governor comes and taps you on the shoulder, and you are considered a wise man or woman, and you ascend to the bench with choirs and cherubs all around you. Now, a lot of these people actually go in to try to get onto the bench at the age of 40 or 45. And at its most pernicious, the problem with that is that then 5 years later they rotate off, go to some firm and say, well, I know everybody you need to know. Just give me the corner office.
I think the wider guy is Domino.
Yeah.
Domino, that's right.
So I just want to...
No.
But I was surprised, and we can take this up later, but I was surprised that you were comfortable with this idea of treating judges as policymakers. I mean, it seems like that...
Well, let me be clear. I understood the logic of what he was saying, that the higher up the judicial pyramid you get, the more like policymakers they are. I'm not in favor of that per se at all. I mean, I'm in favor of an appointive system. They call it, unfortunately, and welcome to unfortunate nomenclature, that the big debate is over merit selection. And so all the defenders of elections go nuts. Say, what, you're saying that the elected judges aren't meritorious? And I swear I've seen these arguments break out at conferences like this, and they last 20 minutes. 20 minutes, these people debating about whether merit or appointment. Okay, if that's where you want to spend your bullets, go ahead. But No, I'm in favor of an appointive system using politically variegated vetters of the nominees. One problem with judicial performance evaluations, however, and it's an interesting one, precisely on this point is, okay, so Judge Obie, all these, you just look like a judge, actually.
So wise.
I hear that all the time.
Yes, exactly. So Judge Obie receives all these performance evaluations, and let's say that he's in a contested electoral district, not one of these ones dominated by one party, and he's gotten all these judicial report cards, basically, that have told people how well he ruled and what he knew and what his strengths and weaknesses were. I'm now going to challenge Judge Obie. I've been a lawyer for 20 years, never sat on the bench. I get to take his performance evaluations and just pull them for any selective critique that I want to and run against him based on a performance evaluation that I never had to endure because I'm not sitting. So even this is problematic in that sense, that incumbents, in that sense, it's not unlike any incumbent who has a record. You're running against an incumbent who has a voting record. And so people will, but again, that goes back to this notion of getting more people to understand what a judge is and isn't, because I think, by and large, because we're so results-oriented, if one judge lets out one Willie Horton who goes and commits one infraction, that's what that judge is known for, independent of however he or she ruled in 1,000 different ways on 1,000 different questions.
We read the Fifth Circuit and the Supreme Court decisions in Lopez-Torres, and the Fifth Circuit in particular described the machinations in New York at the party level of putting people on the ballot. That, I take it, is our system going forward now that the Supreme Court has ruled. Is there any realistic hope of reform, or whatever you want to call it, now that the legal threat is gone?
No. DeFrancesco and Weinstein, and who are respectively Senator DeFrancesco is the chairman of the State Judiciary Committee, and Helene Weinstein's the chairwoman of the Assembly Judiciary Committee. They have both introduced bills in the past. They go exactly nowhere. No one had. The problem is, it's very Soviet at the end of the day. I mean, neither party has an incentive. It's Coke and Pepsi. They've carved up their different marketplaces and say, okay, well, I'm the Republican Party. I'm never going to get anybody elected on the Upper West Side of Manhattan. So I'll give you, and so the party bosses, it's completely in their interest to maintain the status quo. And I think, as we've seen for the last 5 years, Albany is not necessarily. I always hate these things. It's the worst legislature in the country. Well, I've covered Sacramento and I've covered D.C., and Albany's no worse, as far as I can tell, in Springfield, Illinois. Of course, before I lived in New Jersey, I grew up in Cook County, where the shibboleth was vote early and often. So I may have been jaded from the outset. But the short answer is no, I don't think so. I really don't. I don't know. I can't imagine. And the problem is, again, whose incentive? To make changes, structural changes like that, you usually have to have something that's going to achieve escape velocity, some argument, some crisis. You go back to my point about the town and village justices. I mean, so that's how, for the first time in history, the Commission on Judicial Conduct gets its salary doubled, and in my opinion, it's to go after the wrong guys.
But even after those revelations in the Justice Court series in the Times, you say the Commission on Judicial Conduct got some more money to do its work, but I don't recall a giant public outcry. I don't recall people bearing torches and really getting too worked up about it. It was published. People said, wow, that's really embarrassing. And then a week later, we had moved on.
I think that we may suffer in that respect from, it's kind of TV-itis. We only care about these judicial narratives and scenarios to the extent that they get really sexy. And so if you then try to go into the everyday hurly-burly of systemic reform. It's really, frankly, fairly boring stuff. I mean, judicial performance evaluations, for example, and how you're going to basket the questions and how many questions, you're going to ask. You guys are mostly going to be lawyers, and even you would start saying, "Oh, kill me now. I don't want to go through this." It's fairly pedestrian stuff of necessity. But I'm sure in, Elmira, they were and I don't remember. I haven't read the series and so on, so I shouldn't impugn the town and village justice of Elmira. But in whatever jurisdiction, I'm sure there was a hue and cry. But again, those are isolated jurisdictions. How do you get everybody together to care about changing the system? There's no vested financial interest that's going to do it. And plenty on the other side, yes.
You mentioned the Republican Party of Minnesota v. White case.
Right.
Does any of your reporting or looking at the judges include comments that they make in public or where they've gone, before the media or where they've been published in print?
Yeah, we. See if I can think. I mean, the problem is that most judges are fairly circumspect once they're on the bench. The problem with the Republican Party v. White is that it really goes to things they say before they're on the bench. Although now you're going to start to have incumbent judges who are subject to judicial canons. But what that case said was judicial canons can't prevent them from saying anything. So, they're living in a paradox there. We try to stick with what judges do from the bench with their work. We try not to get. I mean, it's Charlie Ramos, is a very interesting judge in the commercial part. Always wears a bow tie and owns a car racing team up in Connecticut, and so we will report about all sorts of trivia, frankly, but human interest trivia because. Again, we're writing for the people who care about the judiciary, for each other. It's a club, and we're all, so people find that interesting. If Charlie Ramos gave a speech saying, and you'll see this happen occasionally where a judge will come out on some public policy question that's not really before them. Immigration, and they're not an immigration judge, for example. Yeah, we would report on that, and we do. But mostly we try to set our sights on the actual performance of the judge on the bench. Yeah.
I guess I'm slightly perplexed, and it may be because I've missed something here. You say you're in favor of appointing judges.
Correct.
And then you also want these judicial performance evaluations.
Correct.
Once we have the judicial performance evaluation, we look at it and say, oh, this judge is bad. He hasn't been bribed. He's not doing any of these offenses that the commission would remove him from.
Right.
But he's a bad judge. What do I do?
Right. It's a good question. I don't know at the end of the day whether you can have. I mean, there's a couple answers. One, right now the problem is that since they're elected, they are actually accountable to nobody except the next electorate 14 years hence. So they are reporting to an office of court administration and an administrative judge who actually has no power over them. So that's problem number one with status quo. Two. The question is, can you turn the JPE system, the Judicial Performance Evaluation System, into something that judges really care about? One thing we've done is to start to spread their reversal information pretty widely. And judges, if you talk to them anecdotally, they all know their own reversal records and rates. Even though they'll then say, of course we wouldn't want to be judged by that, but they know every dot and jittle of anything that ever got reversed. It's a cultural thing. In some respects, where you would want to publicize this stuff, and again, I might feel differently if I thought there was a bat's chance in hell that we were going to get an appointive system anytime soon. As long as we're not, I want this in place as soon as possible. And if we reach nirvana and get some kind of appointive system in place, I guess I would need to figure out how you would apply the evaluations under that schema. You would of course want to be careful. You wouldn't want to have a numerical impeachment trigger. But it seems to me that you do need to have you could have, for example, a legislative censoring system based on performance that again wouldn't. These are proud people, most of them, most of the people sitting on the bench. They wouldn't want those marks on their record. I mean, again, the outliers, some of whom I've mentioned, really don't care. So I'm interested in the ones who do care and might be affected by a healthier system of oversight. But I don't have a perfect answer to your question. Yes.
Yes, in relation to his question and to the fact that you just said there is little you can do, they are not really responsible. There is no body to corner them.
Right.
I'm wondering why the media doesn't do much, or why the media doesn't show much interest. Or how should we mobilize the media in order for this issue?
Right. Yeah, the problem is that you, again, not to disparage the Times, but I think that the Times went after the smallest and weakest cohort of participants by going after the town and village justices. On the flip side, the tabs, used to, do 10 worst judges, and it's sort of like, watching Letterman with stupid judge tricks. I mean, they're, what? Who, and they do that, by the way, in the most nefarious and irresponsible way based on, a handful of anecdotes and then a little bit of scuttlebutt around the water cooler in the courthouse. I go back to what I said before, which is that I mean, we are in the midst of an absolute earthquake in the way that media is produced, disseminated, and consumed. And, one thesis that's out there, for example, I mean, you've got things like, certain, like Amazon, for example, that can actually make a really good margin off of what they call the long tail. So even though most sales takes place here, the fact that you've got an online system that can make a warehouse profitable by capturing all of the tiny sales out there, 5 people who want to buy, profiles of Serbo-Croatian volleyball players. Okay, there's 3 people in the world who want to buy that book, but because you've got an online system that can capture that and distribute it efficiently, you can maintain those books. It's actually a wonderful thing in terms of maintaining diversity of information. The question is, what does it do to this? Now I'm on about my 9th metaphor, so forgive me. But shooting out the middle of the donut. What do you do? What do you do? I know, kill me now. What do you do to get mainstream media to care about something so rarefied as this? And I think the only answer is that at the end of the day, you need nerdy groups like ours to do it, package it responsibly, and turn it into systemic indictments or individual indictments that will hold up, if not in court, then in the court of public opinion, and then you get the mainstream people to hop onto that. Because at the end of the day, even as august an institution as the New York Times does not have the resources to devote to figuring out whether the judges in the Bronx are good at what they do or corrupt or not. It's a Herculean task. And, I hate to sound like a media basher, but it won't sell papers. So we need a reordering of a lot of stuff like this, but we need to accept the fact that it's not going to be easily convertible into a high profit margin for mainstream media. Yes?
In terms of the experience of justice in the community and a sense of fairness, I'm a big one on trying to bring up a point in public discussions about normalizing things. And what I'm trying to go to here is that the sense that we have of fairness is really a human art form. And it seems to me it's developed or it's tied or corresponds to the experience you have of having seen fairness arrived at.
Yes.
And if the forum, let's say one forum that I thought of earlier when you were speaking, is the forum of the living room dialogue to solve the world's problems.
Uh-huh.
If that forum isn't really either engaged or effective, if people aren't vetted privately to act in a vein to achieve justice out of, I'm just saying exactly that, out of their living room,
Right.
not out of responding or reacting to a court case or what they read in the newspaper,
Right.
but what occurs in the living room as far as what are the problems that you're facing, or what's the problems that the community is facing.
Right.
I mean, or
Well, that's. I think that the public education component. I think this response to what you're going after is vitally important. So that, for example, we plan to roll up this information again, albeit in an electoral environment, and create voter guides, so that people are going to see information about judges that actually talk about the judge's procedural performance. Not, oh, you remember this judge because she exonerated the crazy guy who pushed the woman under the subway. People say, that's it. That's the judge I want to vote out. Well, the judge might very well have been following black-letter law on whether the defendant was competent to stand trial, and it's important for voters to realize that. You can only get there little by little. I would say this. We are in a hyper-partisan and polarized, and not just in terms of parties, polarized atmosphere that we didn't used to be in, and there's a couple reasons for that. But just one statistic that you might find interesting. So 30 years ago, 25% of Americans lived in what political scientists call a landslide county. A landslide county is where one party or the other wins by at least 20%. Today that number is 50%. Of Americans.
It was 20%?
It was 25% 30 years ago. It's now 50%. The reasons for that, I think, are twofold. One is bothersome, and that's that I think politicians and their public relations specialists have manipulated that process consciously for get out the vote for all kinds of reasons, for all kinds of understandable reasons. But the other one is actually probably a reflection or an effect of something good, and that is education and mobility, and that people can, actually choose communities where they want to live based on characteristics that they have self-identified. So I lived in San Francisco during the 90s when we were going to move back east so that I could work with the estimable Mark Obie. We wanted to pick out a place to live. So I live in Maplewood, New Jersey. Why do I live in Maplewood, New Jersey? Leaving out any ideology, it's one of the most diverse suburbs you're going to find on the planet. And I had grown up farther out in New Jersey where there was literally one black kid in my high school. And I didn't want my kids growing up in that environment. So we consciously picked an extremely integrated suburb. For that reason, well, other people make other choices. And the problem with that is that long tail I was talking about and the landslide counties and what we talked about at lunch with Cass Sunstein and the nichification process of online media, we run the risk of this sort of new balkanization of the country where we're in an echo chamber all talking to each other and nodding our heads in agreement about what I just said.
Yesterday, I voted in the Pennsylvania primary, and when I went, the county party gave me a little sheet that said, vote for this person, this person, this person, this person.
Who gave you that sheet? I'm sorry?
The county party.
Yeah, sure.
Do you foresee an institute such as your own or something like it? Is it possible to have a sheet like that for judges that breaks it down simple enough that you could get a sheet that would...
You mean endorsing people?
Look at it.
You mean endorsing people?
I don't know if it's endorsing
Yeah.
or if it's having the judges that are running, and what information could you list on that someone from the public would go in and be able to have an idea more than just the name that's on the ballot.
Right. So when we count, it's going to be hard at the end of the day to get people to pay a lot of attention to something that they don't care about, and you can't trick people into it, and you can't force them into it. And I can be as Pollyanna as I want, and they're going to, at the end of the day, say, "You're boring me. Go away." Okay, but that said, that doesn't mean you don't try, and that doesn't mean that you don't put out the best and healthiest information you can, on the theory that the mainstream media might actually end up running it through their own megaphone. And at least we would get out of this situation where the periodic demonization of a particular judge for a particular outcome. So anyway, the short answer is if you can get something that will focus on process, that will focus on metrics that reflect that process, and will treat all judicial candidates on that basis rather than on their jurisprudential philosophy, it'll be better. Can you make people vote? No. Can you make people vote for the right reasons? Whatever you think they are? No.
I think we've run out of time for the public portion of this talk. We'll reconvene as a class in 15 minutes, but we want to thank you, Dirk, and we'll be back.
Thank you.